electoral politics, which word struggled on your tongue, but ultimately you did speak to it quite effectively. The judicialization. Many times we judge our judiciary on the basis of presidential elections. And we forget that there are 290 and 1,450 other elections based on the same register. But what do? We judge it on the basis of presidential election, which calls into question, perhaps now going forward, should we separate presidential election from all the other elections so that we focus on it? And it's something that I would want to hear from you going forward. And then what I want to, of course, Mr. We are talking about the ODPP. Sometimes I hold the view that there are too many cats set to catch the rat. Every institution thinks that they have a role in all these things. And what happens, therefore, is that there is the blame game. We have too many institutions, too many laws, and as my friend Mohisa Kitui once said, and I agreed with him, and I said it yesterday, political bad manners will not be resolved through legislation. And we think that it will be. And that is why we have a forest of laws, and I sympathize with Christina Gimba, because I'm quite certain that in the next 2 years, in the run-up to the next election, you'll be asked to propose other pieces of legislation to address the question of election in this country. So those are the issues, in my view, that have emerged from the presentation that have been made. And of course, Orago judicialization, I was responding to that question that you raised. And I want to hear what it is that the floor thinks about some of the issues that have been raised, remembering always that it is access to justice in electioneering period in the 21st century in Africa. And very lastly, and I want you to read the report that was delivered by the Tana Forum at its meeting in Bahir Dar in Ethiopia on the 14th to the 16th days of October, which is last month. Africa is crumbling. And Africa is crumbling because of elections. If you go to the western part of Africa now, there has been a coup d'etat. I think there is a military administration in Mali. There is a military administration in Guinea. There is a military administration in Chad. There is a military administration in Burkina Faso. And of course, a failed coup in Guinea-Bissau. And you can see that Africa is crumbling. And it crumbles immediately or just before elections. Right now, if you go to Nigeria, the elections are due in the year 2023. And only last week we are told that a contingent of Boko Haram have arrived in Lagos to torpedo the elections. So, when we talk about electoral justice, what faith do we have in our institutions? In this country, we only believe in judgments that favor us. If you lose a case, then the judges have been bribed or otherwise compromised. The judges can never win in matters election. Now the floor must intervene, if only to eliminate some of the heresies that have emerged, or to strengthen. And I can see the good doctor on this side, Evans. May we have three? So in that order, one, move the mic from this side. 1, 2, 3, 4. Short interventions. Don't thank us if you feel you've thanked us.
Quick reactions. Good morning, Dr. Omwara. Democracy. A read of the Kenyan Constitution would reveal to us that there is a subtle hint of the emphasis on voting or electioneering as the essence of democracy. Because if you look at Article 10, for example, on public participation, and I will humbly ask you, Dean, to read an article by Tiki Nassis, The African Origin of Athenian Democracy. Democracy originated from Egypt, and it was practiced through a tool called the Boule, B-O-U-L-E. It mainly intended for us to reach consensus, to negotiate, to get agreements done. We have discarded that, and we think that by manipulating electoral outcomes, we generate legitimacy. That's it. One more, Dr. Miawa, burdens and standards of proof. These are technical legal procedures of justice, and I fully agree with you that if you look at the Roman origins of some of these burdens and standards, the Supreme Court of Kenya indulged in what I call intellectual heresy. It is a mongrel that is unknown, and you only see on their judgment repeatedly. BBI, we also saw the same with their purported handling of some international law questions. We see a court that is arrogant and is not intellectually refined in terms of answering questions of law. Brian sang, efficacy of the ESCJ, we have a problem. And the problem with the ESCJ is political will. I attended a meeting where the Attorney General of Uganda had the audacity of telling us that the court should deal with policy. It should not give binding decisions. That's the problem with the East African Court of Justice.
Thank you.
I have three responses to Brian, Wamwara, and Miawa. And Nicholas, you'll share one question. Now, to Brian, I think you must also address the issue of remedies at that level. I think when you take electoral disputes, you need to ask yourself what is the remedy you are looking for, and whether these forums can give you that particular remedy, so that we address the issue of being academic, as the prof has said. So for example, I'm asking myself, can you nullify an election at that level? And if not, what is the reason why a politician will find it important to go there? Of course, a CSO can go at that level, but a politician wants to get power. That's number one. Wamwara, I think your issue about elections is focused on presidential election, mostly speaking. If I look at the practice now, I see a lot of what we call negotiation and sharing of power amongst communities. It is almost given now in Kenya that one community alone cannot actually marshal enough support and get into power. And you see positions, including chief minister, being created, positions in parliament being shared amongst different groups, and even quotas in cabinet. So in our sense, what I'm saying is that your argument about representation is already happening, even though it is taking a different form. So we can say that Kenya, in fact, belongs to the league of the countries that you mentioned. It's just that perhaps we have one president and therefore we are blinded by that fact. Lastly, to Miawa and Nicholas, I think, number one, I want to understand whether the burden of proof is too high for 14 days, and the fact that the evidence is usually in other areas. Like, for example, Miawa talked about some backdoor things happening, but there's no way of you as a litigant being able to explain. So the question is also, is this inquisitorial process, which is extra-constitutional if we are an adversarial country, is it something that we need now to think about as a mode of resolving those disputes? Thank you very much.
Thank you. Mine is to Dr. Victoria. She talked of women being left out in the political class. I just wondered, how about the independent candidates? Is there any, are the numbers growing? At least here, our independent candidates on political seats is growing. Is that an area where the Tanzanian citizens are looking at? And are there any discussions on the two-thirds gender rule? Are there any discussions? I know she says that they don't have it at the moment. They talk of equality, but it's not enforced. Is there any discussion on it? Thank you.
Is it good morning or good afternoon? We've had very wonderful discussions, and I'd like to comment from what the Dean, Moi University, Dr. Omara, presented in the morning. He questioned whether there's a role for the losing multinational. And he really emphasized something that we should all realistically be aware that Kenya is not really one nation and is a multinational state. And when we go back, when the 2010 constitution was being formed, politicians were given a suggestion by experts, constitutional experts, which I believe Professor Lumumba you were part of, that Kenya is best served if we go through a parliamentary system. But then politicians met here in Naivasha and then they agreed and said, let's go ahead and do a presidential because the president will then be powerful. And we're all suffering from the mess that the politicians put ourselves into. And going forward, we're going to have a tough time because Kenya will always vote ethnically, and our only hope will maybe be that we emphasize on good governance in our counties because the constitution might not be changed very soon. And then I'll have a comment on what our good brother, Dr. Nicholas Orago, presented on the judicialization of politics, electoral politics. I want to say that the good side of this, although the judiciary will be blamed a lot, but in a multinational state like ours, where elections are contested, the judiciary has played a critical role in resolving election petitions by giving the losing candidate some time to cool and even the supporters to come to the reality that we've really lost. And that could be the good side. But I'll finish with a question on what Dr. Victoria presented in the context of Kenya, or what she was even saying that in their law, maybe in Tanzania, there's no issue about that women should have, there should be an issue about gender representation. In our Kenyan constitution, we already have that there's no gender that should have more than 2/3. But as it is, until now, we've not resolved it. What is the way forward? Is it the law that must be changed, or is it the people that must change? Or should we just say 2/3 men will vie and then 1/3 of women? I don't know how we're going to do it, but how realistic is this? Thank you.
Thank you very much. Let's have the presenters respond. Then we take another round.
Will you allow me to add a question? Thank you, Prof. Still on political parties, Dr. Victoria talked of the two parties, Chadema and CCM, and I just wanted to know, are there other political parties which are headed by women in Tanzania? You see, in Kenya, we have had like Martha Karua heading NAC, we have had Charity Ngilu, we have even had Julia Ajambo heading political parties. I just wanted to hear from Victoria, are there other political parties where women have been heading, or their deputies, or they have held any of the posts that she mentioned in her presentation? Thank you.
Okay, I don't think I have so many questions. Professor Lumumba's questions. It seems that extra-constitutional constitutional practices is an oxymoron. Yes, it is. But this is what I mean. I am talking about those acts and omissions or practices that are first constitutionally impermissible in law. But they have become so normalized and routinized in our practices that they have gained constitutional legitimacy or rectitude, if I may use that word. And they do so, they gain this constitutional normalcy and routinization, either through judicial pronouncement, administrative practices, and as well as even legislative sanction. Okay? Let me give you a very good example of one. The Political Parties Act, and I experienced this during the time that we were doing nominations and all that. The Political Parties Act talks about direct and indirect nominations. And indirect nominations and indirect nominations mean the party can sit and decide who to give a ticket, okay? Or you can do so through a normal universal franchise, which of course is the most democratic thing to do, the most democratic thing to do. Now, within the party constitution, and this was very strange to me, and I realized the party had several options. And the last one of them, by the way, for your information, the last one was universal franchise. That is to say that a political party leader somewhere, Raila Odinga, can decide, you know, I know this guy has won through universal franchise, but the party has decided. And you know, these questions would come through the court, and the court says some courts were political parties dispute tribunal would agree with the party's decision, because the party would say, look, the law allows us to select who becomes our flag bearer. That is to say that a political party can actually be a determinant of what is who gets elected, who doesn't get elected, which of course, you know, it goes against the democratic ethos. That's what I'm talking about. But it's been so normalized that people don't even look at something like that as very, very strange. It was only, I think, Justice Ochieng in Kisumu who said, look, but it seems there is a violation of a constitutional principle here. And I think in one instant, he even redirected that there be a repeat of election through universal franchise. The second one, of course, is talk about nominations into parliament because of special interests. And then you have Oburu Odinga representing special interests. What are those special interests? But nobody questions these practices. You know, it's a constitutional practice, but the actualization of it itself really violates the constitutional principles. Those are some of the things I'm talking about here. Again, when it comes, let's talk of another instance of a judicial misinterpretation. And by the way, some of these extra constitutional practices can come through judicial overreach, judicial misinterpretation, and even misconception of the law. The total valid votes cast, the Constitution talks about if you get a majority of the valid votes cast. Historically, even in the old Constitution, all the votes cast, not valid votes cast, all the votes cast, when somebody walks into a voting booth or into a primary school to vote, he has gone there to vote. Now, when handlers handle his vote and they decide this is a spoiled vote, this is an invalid vote, it should not matter. But you see, there was a convenient reasoning that came in 2013 because really they were looking forward. They were looking to a way in which Uhuru and Ruto could be pushed to the 50% plus one margin. Then they came up with this notion and concept of valid votes cast, a language that is not in the Constitution, by the way. And even if you look historically in the old Constitution, you know, there was no such thing as valid votes. There was a thing like votes cast. If somebody has walked into the ballot, into the voting station and cast their vote, whether it is spoiled, whatever it is, whether he draws a piece of paper, you should count it as somebody who has expressed a political choice. It is not for the Supreme Court to decide votes cast means valid votes cast. Then they start splitting hairs between ballot papers and votes. Yeah, yeah.
If you look at page 2, you have the abstract of the proposed paper by Dr. Miyawa. Let me have Victoria before, because I'm quite certain technology can work against you and you disappear. Victoria, you in the land of the living. Victoria? Victoria?
And could I add some question to Victoria before she answers?
She may have left. She's online? Then.
Oh, you've muted yourself. Oh, now she hasn't muted, yes. You've muted.
One more question before you come in for 2 minutes?
I think as I was listening to you, I think the numbers you presented were the actual nominations. Could you also have told us how many presented themselves for nomination? So that if there is a discrepancy, it may not be, let us